All right, we'll take up the next case of DUR-RICH Realty versus CALZARETTA.
While you all are getting ready to proceed, I just wanted to observe that apparently the theme for today seems to be in part, the conduct of lawyers in cases. And it's unfortunate enough that we have a case here involving a lawsuit, mother and son. But the briefing in this case that involve personal attacks on the lawyers. If you think that that assists in the advocacy of your case, you're both wrong, and you both did it, and it's not helpful, and it's not desirous from our perspective to see that kind of language in briefs. So that said, you may proceed.
If it pleases the court, I'm August Stanton. I represent the appellants, and I'm here on their behalf appealing to you today to set aside or vacate the final judgment entered in this cause against DUR-RICH Realty in the amount of $51,440.90.
How much time do you wish for rebuttal?
Excuse me, Your Honor?
How much time do you wish for rebuttal?
5 minutes. Thank you.
Go ahead.
You think that this was tried by consent, which seems to be a position taken by the appellee?
Yes, and Your Honor, I would refer to the record. At 1037 in the 2 or 3 pages that follow, the court was advised that you can't do this. You can't make a ruling that is dependent on the movement being a shareholder, because that issue has to be decided at a trial. And the court agreed. The court did not disagree with that. In fact, the trial on the issue of whether he was a stockholder was on a court docket at that time. And this actually goes to my third point, but perhaps it's the most important point to start with, is to read what was the ruling of the court. And the ruling of the court, if it had been entered, we wouldn't have a basis for an appeal. The ruling of the court was, I find on the motion for attorney's fees in favor of movement. He set the amount, and he asked, how much time do you need to pay it? And I said, I think it should be when the case is concluded, when we determine who the stockholders are.
Well, you all had agreed to produce documentation through discovery, correct?
Yes.
And that was not done, well, not to the extent that had either been agreed upon or ordered by the court, correct?
It was done. But
well, there were no bank records, checking account statements were not provided. I don't think you can stand before us and tell us that there had been discovery completed in the case.
Counsel agreed that all documents requested had been produced before the hearing. The bank records, along with all of the mother's personal credit card accounts, were not available until they were ordered and obtained. But it is true, while we produced essential documents in the beginning of the case without order of the court, some of the documents were objected to on the basis that they were not being sought in good faith and for a proper purpose.
So there's discovery that's ongoing, and the trial court has an evidentiary hearing in terms of whether, who is at fault for the failure to comply with the discovery order. Nothing terribly unique or uncommon about that at a trial court. You agree?
It is in this instance, Your Honor, because the case that The count that was before the court is the count, a shareholder's cause of action seeking records.
I understand that, but you all have agreed to produce discovery. So it's not like your position was, no, Judge, you have, before you can do that as a predicate to engaging in discovery, there has to be a determination that that he was a stockholder and that the shares had been delivered to him. That wasn't the position that was taken. It was agreed upon to conduct discovery, and then the trial court at an evidentiary hearing makes a finding that you were violating discovery orders. That occurs day in, day out in every trial court in this state. You agree?
Your Honor, I don't agree. I don't agree in that.
You've never sat on the civil division of a trial in a circuit court, because I can tell you that those disputes are routine.
But remember, this has gone on for 2 years. Constant attacks and motions for documents. Some didn't exist. We did agree to produce them. And the defendants ultimately did produce all of them. And the court...
Whether or not it had been produced is a determination that the trial court makes, right?
Yes.
Okay. And the trial court made it in this case.
Yes.
So the award of attorney's fees doesn't seem to be critical or any type of aberration or violation of law. What seems to be the problem is the findings made in what was called a judgment that he was a shareholder and that the shares had been delivered, which effectively ended all work on one of the counterclaims. That seems to really be the issue.
It is. There are two aspects to this. You could, and again, if the court had stopped, or excuse me, if the documents pleading signed by the court had been the court's ruling, I couldn't have appealed it. We did participate in the hearing that determined the amount of the attorney's fee, and that's where it should have stopped. And then when the case was finalized and the counterclaims that, if proven, would have shown a basis for either bad faith and improper purpose, or upon finding that he was a stockholder, at least that were the documents, because the statute does provide, that if the plaintiff wins, there will be an award of fees unless the corporation can show that they were withheld in a good faith belief, a good faith basis for believing that they weren't appropriate.
Well, but
that hasn't been decided yet. That trial is pending.
But that was really part of the subject matter of the hearing, was it not?
It was, but it cannot be, and that's where I say, if it had stopped with his order, which went on to say, well, if it's not paid, we'll decide what to do when the trial is over. Right. We will decide what to do, which would mean that if the plaintiff, or excuse me, if the appellants prevailed on the counterclaims, even if they lost the issue of whether he was a stockholder, if they prevailed on any of the atrocious counterclaims about bad faith and misconduct and improper use of the materials that were being produced, and these are not specious claims. They're affidavits by third parties on record that are supporting what the trials would show.
I'm just trying to focus on where you think the trial judge kind of went off the rails here, but it strikes me, where did this concept of a prima facie determination come in? Is that found anywhere in 607?
No, and I can't find any cases that say that 607 should proceed to a trial as opposed to a hearing, but it stands to reason it should be a trial. There is no basis for a final judgment in our system except default final judgments where the damages are liquidated or a motion for summary judgment. Otherwise, it must come through a trial ordered in accordance with 1.440. But back to Your Honor's point, okay, the findings as to the amount of attorney's fees, perhaps that could be undisturbed. I think it should be vacated just because of overreaching on a point on the part of the court or opposing counsel. I can't help but point that out. I didn't do it. I didn't write the final judgment. It's not what the court ordered. The court ordered, if they don't pay, we'll decide what to do when the case is over. And the final judgment, for which execution issue, and which is tied up, and it's in the record, over $100,000 of proceeds, alleged to be escrow proceeds of third parties in some instances, before the stay was entered by the court, it's a horrendous result. So I'm asking that the court vacate the whole thing and say, guys, just go to trial. It's not been the best managed case from the attorney's standpoint. And I take full responsibility for letting a lot of it happen. But I'm the best my client has. I am not a litigator. And I agree with the appellee's answer brief in two regards. One, he agrees with all of the law that I cited. And two, that I was woefully ill-prepared for that hearing. And I was. But I went to that hearing.
That's actually the part of the brief that I was most critical of, because I think it's whether you were or weren't, I just, an attack on you personally just doesn't seem appropriate to me. It could have been done
Mother agrees.
in a little more graceful fashion, but be that as it may, if you want to go ahead and, throw yourself on the sword, feel free.
I went to that hearing with an order by Judge Majid, who had just heard the same motion a month earlier, and he agreed with my motion for a stay. He agreed that this matter could not proceed until the matter of issue of stockholder.
A subsequent judge is not bound by the prior judge's ruling.
In fact, Judge Majid could have changed his mind, and even if he had kept the case, and
Yes,
I changed my
and
mind, we're going to have a hearing. So
I don't dispute Judge Kuhn's right to overturn it, and I shouldn't be arguing why attempting to proffer an excuse for not being prepared. But I did have a right to assume that the court would follow the stricture, the rules of 1.440, and that a final judgment could not be entered as a result of
let me
this
ask you this.
hearing.
If they had come in and said, Judge, they promised this discovery in front of the court, they stipulated to it, they haven't produced it, all of it, or they didn't produce until we, went through filing various motions, and our attorney's fees are $40,000, and then the judge had a hearing on it. If this had proceeded as something on a motion to compel, would the evidence have supported a determination that because of a failure to produce discovery, these sanctions were being imposed, attorney's fees?
Yes, I think the court does have inherent authority to enforce its orders and to enter an order for sanctions. This isn't an order for sanctions. There was no finding.
Right, but in this case, if the court had imposed the attorney's fees for failure to produce the discovery pursuant to the parties' agreement, and the order ended there and didn't say anything about being a prima facie proof of being a shareholder, would you have a basis to contest that?
I don't think so, because it's interrelated to the pending causes of action. It was only the step of making it a final judgment for which execution issue when there are not only just interdependent, interrelated causes of action, it essentially decides those causes of action. And that was an issue early on in this appellate process as to whether this was final. Is it final? Because there are these pending matters. And why should Judith Richmond be allowed to be an appellant? Because she's not named in the appeal. But the court finds all of her affirmative defenses and defenses that her right to go to trial and prove that he is all of the torts that she alleged, torturous interference, violation of the Florida Trade Secrets Act, if she proved that, there would be a good faith basis for withholding some of those records. But early on in the case, it was decided we can't make this case about production of records anymore. Give them everything they want. We can't fight it anymore. It's too hard to get time before the court. We're spending too much judicial labor on it, or attorney's labor, and everything was produced. It took time, yes. And sanctions, the court did not find that there was any contemptuous conduct. And I think the reason it declined to do that, there was no ruling one way or the other, but I think the reason it declined to make a ruling was because it had to wait until the case was over to find out what are these arguments that there's some bad faith.
What specifically was noticed for hearing?
Motion for attorney's fees under count 2. It actually also noticed count 2 of the complaint, which would be, in essence, calendaring the trial on count 2, which was the shareholders' action for records and attorney's fees for having failed to produce them. And there is an argument that because it was noted that the court, that maybe waiver is present, but it wasn't present, because the only case I found that got close to this is the Amber reinforcing case that I cited, where the court found, it reversed the trial court that had vacated its decision because the notice wasn't proper in compliance with 1.440. What it found was, wait a minute, the court did set the trial, it did order the date for the trial, it just didn't mail the notice. The notice was served by the attorney, and they said it was done without objection, and they were not going to allow gotcha tactics. But the trial was noticed and was set by the court. In this instance, the court was not party.
You've just gone under 5 minutes. Okay.
Thank you.
Mike Riemenschneider for the appellees. Let me first apologize for my unprofessionalism in the brief. It was obviously wrong, and I apologize for that.
Thank you. Let's talk. Where does this concept of a prima facie determination as to the shareholder status come from? I don't see it anywhere in 607.
I don't see it anywhere in 607, and quite frankly, it came from the mind of Judge Turner. He raised the fact that there was this...
You agree that that's wrong?
I agree that the use of the term prima facie is wrong.
And I don't understand how you go in for a hearing on attorney's fees and end up with a final judgment on the counterclaim. Because you would agree that the findings that were made in that final judgment would be res judicata on the counterclaim, would they not?
I think that that as part of the analysis of 607.1604, that there were defenses that were interjected by opposing counsel.
Now, normally these cases don't turn on whether someone is a shareholder or whether a stock certificate was delivered. Typically, these cases turn on the reasons for the production of records and what people are doing with the production of records. Would you agree?
I would agree with that, yes. It typically has to do with the production of the records, but the court has to make a determination before he orders the production of the documents that there was a shareholder involved. Otherwise, under the statute, we're not entitled to look at any of these records.
Well, but of course the parties can agree that we're going to go ahead and give these to you without waiving our defense that he was not a shareholder.
But that did not happen. There was no waiver at any time. This case has been fought tooth and nail the whole way.
They agreed to give you records before there was a trial on whether your client was a shareholder or whether the shares had been delivered, correct?
They did not produce to us all of the documents that were ordered by Judge Turner to be produced at any time, including up to today.
There was never been a determination after a trial as to the counterclaims and defenses raised that he wasn't a shareholder. And I recognize from the record that I'm not sure that that's going to be a winning strategy, since she seems to have acknowledged that it was her signature on the stock certificate. The second part of it was whether it had ever been delivered. And I'm not talking about whether they win or lose, but I'm just talking about the procedural method in which this came to be. And that is that there never had been a trial on those issues.
There had never been a trial, but there had been 2 evidentiary hearings on the question of whether...
Aren't you entitled to a trial on your defenses, on a declaratory judgment action? Aren't you entitled to a trial on that?
I think things are different, Judge, when we've got 607, 1604 involved, where the court has to make a determination right off the bat whether...
What case do you cite for that proposition that 607 is an exception to the proposition that affirmative defenses and counterclaims are to be determined after trial?
Well, it says in 1604, I don't have a case for Your Honor, but it says that the court may summarily order inspection and copying of the records demanded at the corporation's expense, but it has to first make a determination if the individual is a shareholder or not, and we had that hearing in March of 2017.
Yeah.
And he found that there was...
Prima facie showing, which exists nowhere in the statute.
True. So do you throw out the ruling? Do you throw out the evidence? I think that Judge Turner used the term prima facie incorrectly here, but the fact of the matter is the evidence was heard and was determined that our client was a shareholder, and then when we had the hearing on...
And wouldn't that be res judicata on the counterclaim and on the affirmative defenses?
I think it has an impact on it, yes, Your Honor.
Is that a yes? It would be...
Yes, I think...
So it's over.
I think the determination of shareholder...
At that point, you've gone from a preliminary, early in the case hearing to a complete resolution of the counterclaim and affirmative defenses without a trial.
No, I don't think that we've resolved all of the counterclaims and affirmative defenses.
You resolved the count on declaratory judgment. I mean, they brought a declaratory judgment count that said that your client is not a shareholder. That's what they sought in their counterclaim.
That's what they've asserted. That's what they've put evidence on in both proceedings that we've had on this issue.
So is that count now resolved?
I think that count is resolved, yes, sir.
Okay. But didn't the judge's order say they could still raise issues about delivery, and because there was only a prima facie showing of a shareholder, didn't the order allow them to challenge whether he was a shareholder or whether there had been a delivery?
Well, I think the Judge Coons did not talk about anything being prima facie. He made the determination once again that there was shareholder status as well as a good faith and a good purpose for going forward like we did. So he made findings based upon the evidence and the defenses that were raised by counsel.
But did the order say this, the defendant or the defendant can still proceed on its counterclaim? And if so, how is that consistent with what?
Well, I think the counterclaim hasn't been resolved in this sense.
Well, that count.
I think the issue of shareholder status, because of the unique nature of trying to get actual stock or actual documents from a corporation, makes the determination, the court has to make a determination of shareholder status. I think declaratory count has been resolved because of the findings after 2 evidentiary hearings where everybody has testified on the issue. And
Would an appropriate procedural way to get to that would be to bifurcate and say, we're going to trial on count 2, or whatever count it was, the counterclaim, and have an evidentiary hearing to determine whether your client's a shareholder. Would that be appropriate? Because that would affect everything else afterwards, the various other counts, right?
right, Judge.
So if you bifurcated it,
I noticed it for trial.
you'd notice it for trial, right?
Right.
Okay. And this was never noticed for trial.
This case was noticed for trial several times.
It was never set for trial.
It was never set for trial, no, sir. The issue,
And despite the fact that it was pending on a docket, you present to the trial court a final judgment that resolves that declaratory judgment count.
I present to the trial court
It was a final judgment that resolved the declaratory judgment count.
that was part of the findings of the court in that hearing.
I just don't know procedurally how you can do that.
Well, procedurally, we had to prove that there was a shareholder involved here. We had, in order to get the records, in order to get the attorney's fees, we had to prove shareholder status. In 607.1604, it says that we are entitled to attorney's fees unless the corporation establishes that the corporation refused inspection in good faith because the corporation had a reasonable basis for doubt about the right of the shareholder to inspect or copy the records demanded.
But that presumes, of course, that you are a shareholder.
Well, that presumes that the argument is going to be raised at the hearing on attorney's fees and costs. I mean, I think that statute, paragraph 3, talks about...
Yeah, if you're not a shareholder, you don't get, those records. And that's why this case is just, it is in an unusual posture because the shareholder status is not typically what these cases are about. They're usually about why you want the records and what you're going to do with the records. That's, those are the typical scenarios under 607. Would you agree?
I've seen cases that have dealt with the issue of shareholder status, and that had to be determined. But I would agree with Your Honor that typically it's about the good faith and the proper purpose. Typically, that goes down as far as whether you're entitled to the documents or not. But that issue, they retained and they put on defenses at the hearing in October. So,
If it was bifurcated and and you had a trial, non-jury trial, whatever on that issue, and the evidence came out the way it did and the judge ruled your way, would that be a final judgment?
yes, on this count, because I think this count was independent of the other counts that were in the complaint. So I think that, obviously, bifurcation was considered by the trial court and denied. But if the court believes that the issue of shareholder status has to be adjudicated, again, after all the evidence has been received twice now, then I guess we can have that procedure, and that procedure should go first. But it seems to me to be an incredible waste of time to have this statute which says that we've got to go out and prove that he is a shareholder in order to get these documents. We did that over 2 years ago, and now we're at the position where we proved once again in the October hearing at 2018 that he was a shareholder.
But we also have the trial judge's determination that, well, that's without prejudice for you later determining that you're not a shareholder or that the shares weren't delivered. And that just seems completely inconsistent. How do you reconcile the two of those?
Well, I reconcile it because, I was at the hearing, and the hearing was that the evidence that was put forth had to do with delivery and had to do with good faith and it had to do with shareholder status. I mean, that issue was raised by them. I was...
So it's a waiver. Are you saying that they implicitly agreed to a trial and that that trial was conducted, and therefore why would there be any need for the trial judge then to make that observation that that's without prejudice for you to raise this later?
Well, counsel said repeatedly to the trial court that he was prepared to go forward and that he had evidence and witnesses to go forward.
But the without prejudice language, that would suggest that the judge says you can raise all these issues on whether the person's a shareholder or not later.
Right.
All right, so if the judge determined later, after more evidence, that your client was not a shareholder, does that mean that it was error to award the $45,000 or whatever it was based on a finding that your client was prima facie shareholder?
Well,
I mean, those
does it-
seem
does it-
inherently inconsistent, you know, to say, defendant, you owe all this money because I'm finding that the plaintiff is a prima facie shareholder, but I'll determine later on, you know, with more evidence whether the plaintiff really is a shareholder, and then if you go back and, you know, take more evidence and determine the person's not a shareholder, what does that do to the first order that both of you all have said is a final judgment?
good question. I don't, you know, I think I raised it in the brief. We're talking about hundreds of hours of litigation and trying to get documents, and it says that we're summarily entitled to a ruling under 1604 that, you know...
It seems inherently consistent to award fees based on a finding that your client's a shareholder, but then still have the option to say you're not a shareholder later on and call the first order a final judgment. I'm just
Yeah,
having
it seems
trouble.
inconsistent to me. I mean, that's why ultimately I took the position in the brief that I did, that this issue has been determined. We've had everybody testify, everybody that had anything to do with this issue.
So your position is the trial court's error was the language about without prejudice?
Well,
That in fact, their count on declaratory judgment has now been fully resolved?
yes, sir, I think that's the truth. I think...
Didn't you write the judgment?
What's that?
Wasn't the final judgment your work product?
It was.
You know, I don't know how you have it both ways.
Well, I don't know how you go with Judge Evander's hypothetical just a minute ago and say, and have the risk of undoing what happened in March of 2017 because there's now a new ruling by the judge.
Well, we didn't draft the judgment.
Well, the judgment was entered by the court. The court determined if the judgment was appropriate or not me.
Right, even if you didn't draft it, we have an order that seems internally inconsistent. Would you agree with that? I mean, on one hand, it awards you money because your client's prima facie shareholder. On the other hand, it says it's without prejudice to show that you're not a shareholder, which if you're not a shareholder, then you wonder how you got the fees in the first place.
Well, you know, as far as getting the fees, I think the fees are authorized by the statute. That's, I mean, we were...
If you're a shareholder.
And we proved...
And if you have a proper purpose, and if the shares had been delivered.
And we proved all that, twice.
Right, and if that's, and accepting that argument, then there shouldn't have been that language about without prejudice to the defendant being able to show later on that you're not a shareholder.
As to count one of his counterclaims, the declaratory action. Now, he's got plenty of other counterclaims, tortious interference, et cetera, but, you know, you got to look at the statute. The statute says, and this is where we were when we started the case, they wouldn't give us documents. We requested the documents. They wouldn't give them to us. So the statute says, set a hearing. The judge has to determine it summarily.
Right, but would you agree to be consistent, the order should have either said, plaintiff is a shareholder, this issue is determined, that makes summary judgment on their count on the declaratory judgment, that issue is resolved.
Right.
Would you agree that that's one way to go, or second, that you're not a shareholder, I'm going to reserve it later, but that it doesn't make sense to say, you're a prima facie shareholder, I'm entering a final judgment granting you fees, but defendant, you can come back and prove that I was wrong about them being a prima facie shareholder.
All right, I basically agree with that. I don't have, I come back to the fact that we've had 2 evidentiary hearings on this
But
issue.
was there anything to prohibit filing and noticing a motion for summary judgment on their declaratory judgment action?
No.
But that wasn't done.
Well, we moved for our fees to be entered, and they raised certain defenses related to the fees. I mean, they could have come in and said, we disagree with the fees, brought their own fee expert, and we had a hearing on the fees. And none of these issues would have been determined, but these issues were raised, so we had to deal with them.
But they're raised without having been noticed for trial, and they're raised without there being a motion for summary judgment. It just seems that's the, either you bifurcate it and try it first, or you file a motion for summary judgment on their declaratory judgment action and go that route.
But that throws out the statutory scheme where a corporate shareholder is trying to get records.
But again, typically, the status of being a shareholder is not what these cases are about.
Whether it's typical or not, that's what the evidence was that we were facing at the time of that hearing in March of 2017.
Well, let me ask you this. Does the statute authorizes fees if you're a shareholder and you request documents and you don't get them?
Right.
Does the statute authorize fees if you prima facie show you're a shareholder, but it hasn't been fully resolved and you don't get the documents?
Who knows? I mean, prima facie is not used in the statute. I think that a determination of shareholder status, whether it's prima facie or not, raised an issue that they could have taken up, I think, but they could have said, we're not producing anything because you're just a prima facie shareholder. You're not a real shareholder. We went forward as a shareholder under the court's ruling. There's no determination or language, any case law that says anything about prima facie.
Is your position that their production of records to you concedes the shareholder status of your client?
Well, I think that, yes, that works into the idea of the fact that we proved that he was a shareholder, and therefore the production indicates and proves that we were in fact a shareholder. You couldn't have it any other way, because the statute says if you're not a shareholder, you don't get anything.
Let me ask you this. At the beginning of the hearing, did they object and say we should not go forward?
No.
Okay.
No motion for continuance, no motion. In fact, he says twice on the record, counsel says, I am happy to go forward, Judge. I am ready to go forward.
I mean, I have witnesses available.
And he called witnesses and he cross-examined our witnesses.
And the purpose was to show that regardless of whether, I guess what they're really arguing, regardless of whether your client was a shareholder or not, the request was not made in good faith. That's really what they were arguing.
Well, they argued, they cross-examined on shareholder status.
Okay. So they're arguing both. You're not a shareholder and...
They argued the whole shooting match.
Okay. All right. All right, time's up. Thank you.
Thank you, Judge. Thank you all. Once again, my apologies.
Thank you, Your Honor.
Let me ask you this. If the proper way to do this would have been either summary judgment or bifurcation, and they don't say we're bifurcating for trial, but you both get in front of the judge and say, we're ready to litigate this issue, and you call witnesses and whatnot, why should we help you out now?
Okay. Let me first correct something that was said, because counsel was not at the earlier hearing before Judge Majid, where his partner stood up but Judge Majid said, are you being denied any records at this time? No, sir, we have all of our documents. Everything has been produced. One of the reasons he said, fine, let's wait till the case is over. I moved to bifurcate this case at the very beginning. Chapter 86, the declaratory judgment statute, provides for the court to accelerate it on the docket. I asked for it. The police opposed it, objected to it, and Judge Coons, who then had taken the case over, said, well, I notice it's on the docket for next month, so we're going to get it all over at once, and I'm not going to bifurcate. Okay. And then they moved for continuance because they had too much work to do to prepare for this big trial. Okay? We went further. I have another motion that I have filed to bifurcate. I no longer want to bifurcate. I can't bifurcate. I have too many issues now that are intertwined on the issue of good faith. These are good causes of action that are pending before the court.
Now, let's say that they, instead of calling it, doing a notice for trial to bifurcate on this portion, let's say they do a motion for hearing, an evidentiary hearing, and both sides get there and they say, we're ready to try this issue. And then they try the issue, and the judge rules however the judge rules, and then you're coming back here and you're saying there should have been a notice for trial rather than a motion for hearing by counsel.
Two things.
But is there a waiver aspect of this?
Yes. I found one case where the court found waiver of 1.440's requirements because the parties stipulated to proceeding with the trial. At every time we appeared before the court on the issue of production of documents, on the issue of, well, in every one of those instances it concerned stock ownership, the court was advised we have to decide the issue of stock ownership first before any of this has finality. And every judge, Judge Turner, Judge Majid, Judge Coons, and Judge Turner, when he returned, just denied a motion for summary judgment that they did file on the declaratory judgment action based upon the findings of Judge Coons, and Judge Turner denied it. We have fought to get this matter to trial. We have never delayed it. We have fought production of documents because there are allegations that my client has been reported to the Department of Revenue, been reported to the FREC, Florida Real Estate Commission of Florida, and other information has been provided to social media to embarrass the employees of my client. And I apologize if I was unprofessional, but I cannot withdraw my opinion that it was wrong when counsel submitted a final judgment to a court that did not rule final judgment. The court ruled that this matter should wait regarding enforcement of payment until the case was concluded. And because that final judgment was submitted, and it was submitted with a letter at 750 that said, Your Honor needs to sign this because it's the only way to force payment. The court had already ruled that enforcing payment would wait until the case was over. So now the court is drawn into, I'm not good, eloquent. I don't know if it's disrespect or what the right word would be. But I certainly am embarrassed, and my client is prejudiced because enforcement started immediately. And that was not the judge's ruling. The record at 1037 makes it clear, and you follow through in those 2 pages, the judge understood.
Mr. Stanton, what do you think we ought to do with this at this point?
I should say, I would ask the court to say, you gentlemen need to go back and work together as professionals, following the dictates of the law. Rule 1.440, which they agree should be enforced. They know I didn't waive it. I couldn't waive it because it's right there in the judge's ruling. Yes, Mr. Stanton, I understand. You have the issue of stock ownership before the court. So send us back and say, guys, start over. It's not a complicated complaint, and the facts aren't that complicated. It's the constant beating for records, personal records of the mother. It has disrupted everything. Go in and say, just go to trial. It's on the trial docket. Excuse me, it was taken off.
All right. Well, your time's up. Thank you. Thank you both.
Thank you for your time.
Court will be in recess.